Struggling to understand the complexities of H-1B or L-1B visas? Wondering which one is the best fit for your situation? Look no further. Welcome to Direct U.S. Immigration's channel, where you get direct access to our most up-to-date immigration and global mobility space. I'm an immigration attorney with almost a decade's worth of experience, and today we're going to talk about the most common U.S. visas available for software engineers. Stay tuned. Thanks for tuning in. My name is Miatrai Brown, and I'm a U.S. immigration attorney based in Washington, D.C. I'm also the principal attorney at Direct U.S. Immigration, where we work with clients in all 50 states and around the world. Before we start, click on the like and subscribe button to follow our Immigration Hub to get the latest immigration information that could be vital to your case. And also, be sure to stick around until the end to get bonus tips on ensuring your visa application is successful. Now let's dive right in. The H-1B and L-1B are two distinct non-immigrant visa categories in the United States, each serving different purposes and catering to different scenarios. While both visas involve employer sponsorship and allow for dual intent, the key distinction lies in the type of employment and the nature of the knowledge required. The H-1B is more broadly applicable to a range of specialty occupations, while the L-1B is specifically for intracompany transfers who possess specialized knowledge. I recently had a client who was interested in moving one of their software engineers from their India parent company to their U.S. subsidiary, but were unsure which route to take. To give more context about the employee, Raj is a talented software engineer from India, holds a bachelor's degree in computer science, and has several years of experience under his belt with their parent company. Raj was subsequently offered a job by their U.S. subsidiary tech company, and because of his background, he could have qualified for both the H-1B and the L-1B, but he had a stronger H-1B case because his role with the parent company did not rise to the level of specialized knowledge, nor did his outside experience rise to that level. Luckily, Raj was selected in the H-1B lottery in the first year he was submitted, and the U.S. company's need perfectly aligned with his start date in October. By working with an immigration firm and experienced professionals who have filed thousands of H-1Bs, the company was able to swiftly move Raj to their U.S. subsidiary without any hiccups. Now let's further break down both visas. The H-1B visa is a popular choice for software engineers who wish to work in the United States. This visa category is specifically designed for professionals in specialty occupations that require a high level of specialized knowledge. So here's how the H-1B visa applies to software engineers and its requirements. So you've got a specialty occupation. So software engineering is considered a specialty occupation, making it eligible for the H-1B visa. This category includes roles that typically require at least a bachelor's degree or its equivalent in a specific field of study. Now, for the educational requirements, to qualify for an H-1B visa, software engineers must have at least a bachelor's degree or its equivalent in a relevant field such as computer science, information technology, or a related discipline. Now, a job offer is important. Software engineers must secure a job offer from a U.S. employer who is willing to sponsor their H-1B visa. The employer must file a petition with the USCIS on behalf of the software engineer. The employer must also obtain a labor condition application from the Department of Labor, affirming that the employment conditions, including wages and working conditions, meet prevailing or company standards, whichever is higher. Now let's talk about the cap limitations. The H-1B visa program for initial applicants and those sponsored by for-profit companies is subject to an annual numerical cap, which can impact the availability of visas. The regular cap is set at $65,000 and there's an additional $20,000 for individuals with advanced degrees from U.S. institutions. Initially, H-1B visa holders are granted an approved period of up to 3 years with the possibility of extension for an additional 3 years, and beyond that 6-year limit, extensions are possible in certain circumstances, such as when the individual is in the process of obtaining permanent residency and has an approved I-140. Now, H-1B holders are allowed to have dual intent, and this means that they can pursue permanent residency or a green card while maintaining the H-1B status. And H-1B visa holders also have the option to change employers under certain conditions through the H-1B portability provision. Now, it's important for both employers and software engineers to be aware of the specific requirements and regulations associated with the H-1B visa program. Due to the high demand of H-1B visas, the selection process can be competitive, and individuals are advised to plan and apply well in advance of the need. Consulting with an immigration attorney is recommended for personalized guidance based on individual circumstances. Now let's discuss the L-1B visa. The L-1B visa is designed for intracompany transferees with specialized knowledge who work in multinational companies. This visa category allows companies to transfer employees with specific expertise from a foreign office to a related U.S. office. The L-1B visa is more commonly associated with employees possessing specialized knowledge relating to a company's products, services, or operations. So here's how the L-1B visa may apply to software engineers as well as its visa requirements. So to qualify for the L-1B visa, software engineers must demonstrate specialized knowledge that is integral to the employer's business processes, technologies, or proprietary systems. This knowledge should go beyond what is commonly known in the industry and is employer-specific. The L-1B visa also requires employer sponsorship. The U.S. employer must have a qualifying relationship with a foreign entity, meaning that the relationship must be a parent, subsidiary, affiliate, or branch. And also, the employee must have been working for the foreign entity for a specified period. More specifically, the employee must have worked for at least 1 full year within the past 3 years before filing the visa application. Also, the employee must be transferring from a foreign office to a related U.S. office within the same multinational company. Now, initially, the L-1B visa holder can be approved for a stay of up to 3 years, and extensions are possible, but the total cannot exceed 5 years. Now, L-1B visa holders are allowed to have dual intent, meaning that they can pursue permanent residency, also known as the green card, while maintaining L-1B non-immigrant status. Now, it's important to note that while the L-1B visa is a viable option for certain software engineers that have specialized knowledge within their company that can be infused into the U.S. operations, these specific criteria and documentation requirements must carefully be addressed in the application. Employers and employees are encouraged to consult with immigration professionals or attorneys to ensure a thorough understanding of the L-1B visa process and to navigate the application successfully. As promised, here's some bonus information that you may not know about. For a successful visa application for software engineers, consider the following tips. Thoroughly understand the visa category. Gain a clear understanding of the specific visa category that suits your professional qualifications and goals. Seek advice from an experienced immigration attorney to navigate the complexities of the application process. Prepare and submit accurate and complete documentation, including educational qualifications, work experience, and other related and required materials. And of course, adhere to application timelines and submit all required documents well before the deadline. Ensure that your job offer from a U.S. employer is clear, specific, and in compliance with visa requirements. Verify that your qualifications and credentials align with the educational and professional requirements of the chosen visa category. And stay updated on changes to immigration policies and procedures that may affect your application. If an interview is required, prepare thoroughly by anticipating potential questions and presenting yourself professionally. And of course, be honest and maintain a consistent story. Ensure that all aspects of the application, including the information on your resume, cover letter, and interviews, present a consistent and truthful narrative. Respond promptly to any requests for additional information or documentation from the U.S. Embassy or consulate. And if you are considering premium processing for certain visa categories, this is available, so make sure that you do premium process your application. and maintain a positive and professional image. So present yourself professionally throughout the application process, from initial interactions to interviews. Remember that each visa category has its unique requirements. Consulting with an immigration attorney for personalized guidance based on your circumstances is highly recommended. Last but not least, be sure to check out the caption below this video. We've got questionnaires for different types of visas that we can use to help you determine which visa is most appropriate for you. And if you're traveling soon, we also have a list of some of my travel favorites. So I hope you found this video helpful. Subscribe if this content or information helps you in any way. Comment below if you want me to talk about something in specific, and share this resource widely because you never know who needs answers to these questions. Additionally, if you have any specific questions about this video as they pertain to your unique circumstances, please schedule a consultation with us, also at the link below, and I'll see you in the next video.